right, 25 minutes before 11 o'clock. John Fuller is in the studio ready to answer your questions about the law, perhaps about your own legal circumstances. John Fuller is an attorney at the law firm of Fuller and Fuller right here in Ocala. He shares the law firm with his wife, Janet Fuller. She's also a registered nurse, it says here. The show is called Legally Yours, and the phone number to call John right now is the WOCA Climate Control Source Hotline, 622-9622. And just so you know, whether you're listening to a live show or not, today is Wednesday, June 19th, 2013. Good morning, John. How you doing?
Good morning, Larry. Good to be here.
Pull out my phone just a little bit.
Hope you've had a nice week so far.
Pretty good.
All our listeners have.
Yeah.
Summer's upon us, and it's nice to be here. If folks have questions that may be related to a legal issue that they or a family member are facing, if they've been in a car wreck or have some business commercial litigation type issue, complex family law matter, or Social Security disability, although that's my partner Janet Fuller and my wife's Janet Fuller's area of expertise. We'd be glad to try to help them with them, and of course we always enjoy discussing in general terms legal issues, the legal system. As we've discovered on this program, there's almost nothing in our daily lives that doesn't have some interrelationship with a law, a regulation, a contract, something of that nature that affects our daily lives. So to the extent that folks have any questions and we can help them, we enjoy the opportunity to do so on this program, and always, of course, to come in and talk to you.
Have you ever had a client who was fighting an eminent domain issue? Or
Yes.
There's a story this morning about a pipeline that's going to go from Alabama right through our area. There are certain people who will be in the line of fire, and they are being offered for their property.
Right.
What if they don't want to move? How can they fight that?
Well, that's very difficult. The law basically says that if there is a valid public purpose for the project, whether it be a power line, a pipeline, a widening of a street, a 4-lane highway, a new road, a bridge, an overpass, what have you, if there is a valid public purpose for it, that it serves the greater good of the people at large, government has the power to acquire property to build that structure on for the good of the people. The law says that whatever citizen's property is being taken is entitled to have just compensation from the condemning authority. Now there are some very difficult and very hyper-technical and strange events where you can argue against the order of taking. Principally that the project doesn't meet a valid public purpose, or the manner and method in which it is designed is not the most reasonable, practical, workable, cost-efficient way to meet the public purpose, and the road should go somewhere else. Those are ways that you can challenge government's right to take the property. But the right to take the property is pretty absolute, and the right to just compensation is equally as absolute. Like everything we talk about, the devil's in the details, because what is just compensation?
Exactly.
And that gets into a very specialized body of law that has multiple different elements and issues in it. It is not necessarily just the value of the land. If you say, okay, I'm going to take the 200 feet of the west boundary of your property for this road, hypothetical, and you say, and they say, and the property there is worth X amount of dollars an acre, and we're taking X amount of square footage, prorate that, we owe you $20,000 for the value of the property we're taking. But then you have to look at and say, but wait a minute, That property that you're taking has all manner of improvements on it. I have an irrigation system on it. I have a lighting system on it. I have pavers in the driveway installed. I have an ornamental wrought iron fence that is being removed.
Yeah.
I have several granddaddy oaks that have been there for 200 years that you're going to cut down. And you want to cut that down and replace it with a 5-inch sapling. That adds value to my property that is being damaged and taken away by the underlying taking.
Yeah.
So I get value. I get to recover damages from the taking. I had a case a number of years ago where they were 4-laning a highway, and on the corner of my client's property was literally a 300-year-old oak tree, and he had basically created a business with that as his logo.
Oh, wow.
Okay. Long story short, we got about $25,000 for that oak tree. Now, they had a right to go cut it down. Unfortunately, it's gone. But that was what the value was determined to be because of what it offered.
And was that above and beyond what they were originally offering for the land?
Yeah.
Okay.
Yes. And then, in addition to that, if the taking creates damage to the remainder of your property, if you had a parking lot for 30 cars and they take 200 feet of your property, and now you only have parking for 10 cars, they've damaged your remainder.
Sure.
You get damage to the remainder value. Then if you have a going business on the property and you properly give notice to them that you're claiming business damages because they've diverted the flow of traffic, you no longer are going to have the same retail window of exposure, and you're going to lose business as a result of this improvement. A classic example of damage to businesses. They put the overpass in on 17th Street to go over the railroad track.
Right.
There used to be a car wash there. There used to be a quick lube station there. There used to be a transmission station there. Now that overpass goes through, you have essentially no access to that.
That's right.
So there was a going business. So if you do it properly, you're entitled to be paid business damages for the damage to your business. Also, an interesting feature of eminent domain law is that it is one of the few areas of the law that says that you must have the determination of what is your just compensation determined by a jury of 12 people. Almost every other jury in our system, except for capital felonies, is a 6-man jury. But in order to make sure that there is extra consideration for the property owner, all eminent domain cases are tried by a 12-man jury.
Wow.
So that is a Reader's Digest version of the law of eminent domain.
Yeah.
It is a lawsuit that is driven in large part by expert witnesses, real estate appraisers, business evaluators, forensic certified public accountants, engineers. Will the new construction create a water law problem? Are they going to be taking excess water and increasing the post-development discharge of water on your property to an amount greater than the pre-development discharge that was being caused that is being caused by the improvement? So those are all factors, and I could go on and on and on. I don't want to be overly technical, but I hope that gives you some insight.
But here's what I'm hearing. This is what I'm hearing. If they come knocking on my door, I don't do it alone. I come see you.
Well,
That's what I hear.
I think certainly. It's like when my car starts making a funny noise, I need a mechanic, because I can open the hood and I may not always know whether I'm looking at the spark plug or the gas cap. Okay, we all have different areas of expertise. Many people, when the condemning authority comes there, they have agents working for the government, and their job is to buy the property just as cheap as they can. And they always try to talk people into taking the quick check. And there's an awful lot of people who will do that because they look at how much they're offering them for the property, and they think, that's pretty fair. We could get that. We could take that, and I'll have that check today, and I'll give them a quitclaim deed. And they don't think about all the other levels of compensation that they might be able to recover.
And when that 700-mile-long natural pipeline is going through I'm not really sure when, but I guess what I wanted to say is I'm guessing there will be some people who will be needing an attorney when that day happens because it's going through. So
we'll have it. The fact that the project is going to occur happens in the vast majority of the cases. It is a very, very rare and unusual case where an individual property owner can stop a public project and get the court to rule that the sovereign, whether it be the county or the state government or the Florida Department of Transportation or whomever, don't have the right to take it.
I just saw the date. It sounds like the pipeline will be working in 2017. So next 4 years, next year probably you'll have people coming to you asking.
I'm sure the property appraisers are already out there working, and they're probably doing test borings and taking preliminary survey sites and that sort of thing.
Yeah.
It's an interesting body of law. It's a highly specialized body of law, and the need to have very good expert witnesses is essential in a case like that.
All right, especially to convince those 12 people, right? All right, let's go to the phone. Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller.
Good morning, sir.
You mentioned that topic, Larry, because I went through that process several years ago with the city when they 4-lane right across on Martin Luther King. I see where they're finishing up finally after all those many years. But I used, and you're right, and your assessment, Mr. Fuller, was right on time because I used Charlie Foreman and Miss Thomas and Vanessa Thomas. They represented me. They did a real good job because what I was offered initially was really terrible. It was peanuts by the city in terms of what they not only did they do a good job, but they also made sure that the fella that was running the fruit stand there, he was pretty well compensated.
Now, should I ask Charlie to send some money to contribute for the advertisement on this program? And I say that in jest because Charlie Foreman is a dear 35-year friend of mine who specializes in nothing but eminent domain work, and he does an excellent job, and I have worked with him on many occasions and have actually referred cases to him. So I say that in jest, but you keep plugging Charlie, I'm going to send Charlie a bill.
Yeah, Miss Thomas, she was the actual one that did it, but they did a good job because
they're good eminent domain
they
fellas.
looked at things that I never would, and I wouldn't advise any citizen that's going through that to try and do it on their own, because there are things that you wouldn't ever even think of that you have to go through. Because there was a legal technicality that we worked it out, but it would have been a violation of my rights.
Well, I think everybody does well to consult with an appropriate professional whenever they're facing a situation they're not familiar with, whether it's a chest pain and you need to go see a doctor, or whether it's, like I said, your car's not sounding exactly right and you need an auto mechanic. People who specialize in dealing with those problems, we all need them, whether it's the plumber to come fix our plumbing, the electrician, the auto mechanic. We all provide services to each other in this society, and that's what makes it work.
Right. Let me change the topic for a quick minute there.
Okay.
I was watching this thing with the. I was a little bit out, so I didn't go to my shop today. My back was out. So speaking of specialists, but anyway, so I had to stay home. But anyway, so I was watching this thing where they're selecting, I guess, the jurors for the Zimmerman trial. One of the things that is kind of perplexing to me is the defense attorney is asking the judge not to allow certain terms to be used. And I thought, wow, that's kind of unusual, kind of weird. I mean, there's wannabe cop, vigilante, all kinds of, things that you would ordinarily think that, people would be allowed to use during a hearing. I just thought that was kind of unusual. I'll hang up and, as usual, I always enjoy listening to you.
Thank you, and I always appreciate your calling in. You're always charming and a delight to talk with, and always have interesting questions and comments, and I thank you for taking your time to call us, because that's what makes this show work. I have not followed the Zimmerman trial, or quite frankly, I don't follow very many trials on television. When you work in it every day, the last thing you want to do is come home and turn on the television and watch it again. To try to comment on your observation about the request to prohibit the use of certain terms or phraseology. Here's what I think the basis of that is, and whether or not the defense motion will be granted or the judge will conclude that that's reasonable or not, falls within a wide discretionary ruling of the judge. Our rules of evidence allow litigants, either the prosecutor or the defendant, to file a motion. It is called a motion in limine, going back to the old Latin, means to eliminate the evidence or the testimony from being submitted to the jury. One of the subsections of the Florida Rules of Evidence deals with inflammatory type statements. It's Florida Statute Section 90.403 and Federal Rule of Evidence 403. And it simply says if the testimony or the word or the phrase or the verbiage has an inflammatory context that outweighs any probity value that it would have, and so inflame the jury that it would detract from an orderly analysis of the underlying facts, that the judge has the right to exclude that and enter an order in limine and tell the lawyers and the witnesses not to mention that, not to say that, not to refer to that, and not to argue that. In the two words he used, I think he said vigilante, and what was the other one, Larry?
Wannabe cop. Cop wannabe.
A wannabe, a wannabe cop. I don't know what Mark McCormick's thought processes are on that, but these are words that at least could potentially be interpreted as subjectively conclusive. In other words, is a person a vigilante or isn't a vigilante? Well, the person who says he's a vigilante, that is an opinion. Only experts are entitled to give opinion evidence in our courts of law. That means a lawyer or a doctor or an accountant or a mechanic or somebody testifying in their area of specialization where they're qualified as an expert. Vigilante is a descriptive term that is an opinion of what the behavior is. So I suspect Mark McCormick's, I may not be saying his name right, I think that's it, but anyway, whoever the defense lawyer is, I suspect his argument is that these are inflammatory terms. There was a movie out with Charles Bronson 15, 20 years ago called The Vigilante. And when his family had been killed and his house broken into, he secretly started going around randomly shooting perceived bad guys at night. And so it's an accusatorial type word that has an emotionally charged connotation to it. And the trial should try to eliminate those emotionally charged terms and stick with the facts, and only state the facts. Wannabe. again, same type of thing, that he's trying to make believe and be a pretend cop and go out, So how does he know? How does anybody know what's in somebody else's frame of mind, that they're a wannabe? So that sounds rather speculative and inflammatory. That would be the argument for that.
And you do have another phone call. Good morning. You're on the air with John Fuller.
Hey.
I'd like to know, as a lawyer that goes to trial, and most lawyers that do, what are their feelings about having live television in the courtroom? Are they for that or against that? Do you think the television might take a little bit away the integrity of the whole situation there? And I personally, like with that Casey Anthony, that became such I just think it was way overdone, and to a lot of the extent probably just all it was doing was getting a lot of viewership for the channels that were covering it. And I don't know, I think a lot of special interest groups were interested in watching it, and it kind of fires them up, and sometimes I think that whole thing gets out of control. What would be your feelings on TV coverage?
I personally am inclined to agree with you. Back in the 1980s, I was a member of the Criminal Rules Committee of the Florida Bar, and it was just beginning to emerge, and it was very hotly debated. The argument for it is that we have, by our Constitution, public and speedy trials, the freedom of the press and the freedom of speech, as long as it's not, quote, disruptive of the actual courtroom procedure, should have a right to do that, and the public has a right to know and to be aware of the duty of the job and what's going on in its public institutions, such as a trial court. The other side of that is, does it affect the trial? And I think your observations have a lot of merit. I think that they, especially with lay people who this may be the first time they've ever been exposed to being on television or something of that nature, Andy Warhol said everybody has their 15 minutes of fame, and sometimes people even subconsciously may want to play to the camera. My experience with it has been, and I've had a few cases in my career that were significant enough where there was courtroom cameras. The judge was very, very strict that the camera could not be moved around. It could not interfere with the court process. In some cases, it could not broadcast the pictures of the jurors. It could not broadcast some witnesses. And it could not have extremely bright lights or any kind of audio, and it had to be strictly controlled to try to minimize the distraction. But I think it's unrealistic to think that it doesn't have some impact. The ultimate decision, as you obviously know, because we see it on television at the state court level now, the ultimate decision was that the argument for public trials and access to the courts and the right to freedom of the press carried the day, and so we can have television cameras in state court. Ironically, television cameras are not allowed in federal court. And the big federal court cases that I have tried, the big networks will send in artists who will sit there in the audience and sketch what is going on. And their sketches are oftentimes very close to realistic portrayal, and then you'll have the audio feed, and they'll be flashing up the artist sketches of the witness or the lawyer or the judge or whatever is happening, and you see those happen in federal court cases. It's one of those things that was a balancing act. It has not been, and I don't think that there's been any case where I have been involved where the camera in the courtroom had a significant influence on the ultimate outcome of the case, one way or the other.
Beginning back to like the state or local level here, if a certain judge says, I don't want cameras, TV in my courtroom for this case, could he or she be overruled by like a federal judge?
Not a federal judge, but by an appellate court judge.
Okay.
And the press would be the one to be represented by their attorneys, and they have quite a battalion of First Amendment lawyers that they bring in from New York, Tampa, Miami to argue that courts ought to be open and the right to do this. And it's pretty well established now that the right to have cameras, provided they are not intrusive, distracting, or interruptive of the judicial process.
Right.
And so that's been going on for quite a number of years. For whatever it's worth, 20 years ago when it was first debated, I was opposed to it.
Yes.
But as it turned out, I don't think it makes a whole lot of difference in the end result.
Well, I guess you could say it makes a lot of viewership. A lot of people watch. Everybody you seem to talk to.
Well, starting with the O.J. Simpson case, it gave rise to a cottage industry that was kind of a relief act for a bunch of lawyers, some of whom never even tried cases, to get on TV and wax eloquently about what everybody was doing right and what everybody was doing wrong. And I think every one of the talking heads predicted that Casey Anthony would be convicted and she was acquitted. Ironically, I said from about halfway through the trial that I thought she stood a good chance of acquittal because there was no physical evidence.
Really?
No physical evidence. All right, thank you very much for your answer.
Always a joy to talk to you. Thanks for calling in. Have a great day.
Thank you.
So if I could slip in one quick one about photography in the courtroom. If I'm sitting in the courtroom just as a spectator, maybe I'm an interested party, and I got my camera phone, and I take a picture, and I quickly send it to Facebook, and here comes the who's the law enforcement agent?
Bailiff.
The bailiff. He says, you can't take pictures.
Yeah.
Okay. I've already posted it on Facebook. Am I in trouble?
You could be probably held in contempt of court.
Really?
Yeah.
So don't take pictures in court.
No. You're not allowed to. You as an individual spectator aren't allowed to do that. It's only members of the press.
And I'm guessing it happens more often than... It probably happens all the time.
I've never seen it happen, but of course my attention is not focused back in the audience. What goes on in the back of the audience, I don't know. But you've got the judge and the bailiff looking out, and they are pretty vigilant. And they want to preserve the integrity of the process. They want to avoid it. Sam Shepard, who F. Lee Bailey, that was his first major high-profile case that made him famous back in the 60s. His trial was a joke in terms of media circus. They were selling cotton candy and hot dogs right outside the courtroom. The jury was being bombarded with television and newspaper headlines, and ultimately the United States Supreme Court said that it rose to such an egregious level that it violated his due process right to a fair trial. They reversed the conviction, went back, had another trial. Bailey represented him. He was acquitted.
Wow. It's just an interesting process. By the way, do you call it an audience? What do you call the people in a courtroom? Is that enough?
I think audience is as good a word as any. I don't know.
Well, if you haven't...
Spectators, I think, is what I've heard used most often.
That makes sense, yeah.
The judges will say, I want to caution all of the spectators that I will tolerate no outburst. In a very high-profile case where there's a lot of hot feelings in a jury case, like in a criminal case, and the jury's coming back, and somebody's going to be found guilty or not guilty, and half of the courtroom wants to have him convicted, and the other half want to have him, I have had as many as 6 bailiffs in the courtroom, maybe more, to ensure that nothing got out of hand.
Really?
And then they would hold one side in the courtroom and instruct the other half to leave and exit the premises while they held the other side there to avoid any possibility. No one wants anybody to be hurt physically out of the process. So they do a really good job of keeping our courtroom safe and keeping the process moving smoothly. The bailiffs here in Marion County are all outstanding.
Yeah, I don't know. If I were in your shoes, I think I'd rather be working with the eminent domain case than the criminal case. It just seems like it's less stressful. John, how do we get a hold of you?
Okay, our office here in Ocala, the number is 352 855-447-4292. We have a toll-free number, 855-534-2565. We have offices in the Villages and Ocala, and we'd be happy to help you if you have a legal problem.
Call John if you need any help. If that pipeline is coming through your yard, call John. He'll make sure that you don't get a little bit more than they're offering, I would imagine.
Well, actually, that last quick point, lawyers' fees in eminent domain case is based upon a statutorily set percentage of how much you recover in addition to what was initially offered by the condemning authority.
Oh, my
So
goodness.
the property owner doesn't pay the lawyer, the condemning authority does. So if they offer you $10,000 for your property they're taking, and you hire a lawyer and he ultimately gets you $30,000 or $40,000, he gets paid a percentage of the amount that he recovers over and above what the initial offer was made before you hired the lawyer.
Oh, wow. That's interesting. Okay. If you did not catch John's phone number, call us here or go to WOCA.com, and Robin already has that on the AM Ocala Live guest list. John, thank you for what you do.
Thank you, Larry. Always a pleasure. Thanks to our listeners for calling in and listening.
Always good stuff. We'll take a little break, and we'll be right back.
Okay.
Ocala's information station, 1370 WOCA.
Ocala. ABC News Now. I'm Karen Chase. Standing at the Brandenburg Gate and calling it the fault line that once divided the city of Berlin, President Obama urged Europeans not to become complacent.